are going to open the hearing on 2416. We'll have Natalie do an overview. We'll have the chance to ask Natalie questions. Obviously, unless you've all spent the day, which I'm sure some of you have, reading the bill and digging into it, I doubt many of you have enough time for lots of questions and discussion and that type of stuff. So I really just want Natalie to explain it to us so we can understand it. We'll have a chance again tomorrow to have additional questions for Natalie before we have proponents, neutral, and opponents. So I just wanted to make sure we had this opportunity today to have an overview of the bill so we have a better idea of what we're talking about come tomorrow. And then once we do that, we've got a list of bills we'll try to work, and then we'll be done for the day, and we'll do this all again tomorrow. So let's get started. I'll open the hearing on House Bill 2416, and we'll have Natalie walk us through it.
Thank you, Mr. Chairman. House Bill 2416 makes changes to the Kansas Emergency Management Act. New Section 1 provides that during a state of disaster emergency, when the governor determines it's necessary to issue an executive order that is not expressly authorized by KSA 48925 C1 through 10, that would be to promote the security and safety for the protection of the civilian population, then that the governor shall make a specific application to the Legislative Coordinating Council to seek approval to issue that executive order. That proposed executive order would need to be in conformity with the Constitution and the Bill of Rights of the state of Kansas and the statutes of the state of Kansas. That application would be required to state the reason that the order is necessary. And before making that application, the governor would submit that proposed executive order to the Attorney General, who would review that order and give an opinion as to the legality of the order to both the governor and the Legislative Coordinating Council within 24 hours. Unless the disaster prevented that review. On application by the governor, the chairperson of the Legislative Coordinating Council would be required to call a meeting to occur within 24 hours to discuss that order. The governor or the governor's designee would be required to appear at that meeting to provide information related to the proposed order. And on affirmative vote of 5 members of the Legislative Coordinating Council, the proposed executive order would be approved for issuance by the governor. If the council does not approve the proposed order, they have 3 options. They can amend that proposed executive order and submit the amended order back to the governor, who will then decide whether they want to issue that executive order or not. They can request the governor bring a new proposed order to the council for consideration within 24 hours, or they can deny that order and take no further action. Subsection D provides that orders issued pursuant to this section would be null and void after the state of disaster emergency is over, and they would be able to be revoked at any time by concurrent resolution of the legislature. Subsection E provides that orders issued pursuant to this section shall not exercise a power that is granted in statute in a way that does not conform with the existing statutory requirements or criminalize conduct that would not otherwise be criminal. Subsection F provides that a party who is aggrieved by an executive order issued pursuant to this section can file an action in district court. The court would have to hold a hearing within 72 hours, and they would be required to grant relief unless the court finds that the order is narrowly tailored to respond to the state of disaster emergency and uses the least restrictive means to achieve that purpose. Subsection G provides that the governor shall not exercise a power conferred by KSA 48925C after that initial 15-day state of disaster emergency, unless it is authorized either by this section or by KSA 48924 F2. New Section 2 provides that during a state of disaster emergency, when the legislature is not in session or is adjourned during session for 3 or more days, the Legislative Coordinating Council may extend a state of disaster emergency and authorize the use of the powers conferred by KSA 48925C. On application of the governor, again, the chairperson of the LCC would be required to call a meeting within 24 hours. And the governor would not be able to exercise those powers conferred by KSA 48925C without authorization pursuant to either this section or KSA 48925F, which we'll talk about in a little bit. At the meeting of the council, the governor, again, or the governor's designee would be required to appear to provide information related to that application. The LCC would be able to extend the state of disaster emergency for a specified time. And if that extension occurs, then they would be able to decide whether they want to authorize the governor to continue exercising those powers conferred by KSA 48925C. The bill also provides a list of items for the council to consider when deciding whether to extend the state of disaster emergency or to authorize the use of powers under 48925C. Section 3 amends KSA 461202. That's a statute within the Legislative Coordinating Council statutes to provide that the council shall meet as authorized by KEMA to review proposed executive orders and extend a state of disaster emergency as authorized by KEMA. Section 4 amends KSA 48924 to remove the state of disaster emergency provisions that relate to disasters specifically regarding the spread of contagious or infectious disease among domestic animals. The bill also changes the extension process for state of disaster emergencies to provide that extension may only occur by concurrent resolution of the legislature, except that when the legislature is not in session or is adjourned for 3 or more days, upon specific application of the governor, the LCC would be able to extend that disaster for specified periods of time in accordance with Section 2. If the legislature does extend the disaster by a concurrent resolution, then that resolution would also have to state whether the governor is authorized to exercise the powers conferred by KSA 48925. The governor would be prohibited from issuing a subsequent proclamation declaring a state of disaster emergency for the same or similar disaster if the original state of disaster emergency was not ratified by the legislature or extended by the Legislative Coordinating Council. Section 5 amends KSA 48925 to provide that when the governor issues an executive order, the chairperson of the Legislative Coordinating Council would have to call a meeting within 24 hours to review that order. If an order suspends the provision of any regulatory statute, order, or rule and regulation, that's the power conferred by KSA 48925C1. If the governor is exercising that power, then the order has to specifically state which statute, order, or rule and regulation is being suspended. Subsection C11 is amended to provide that the governor may perform and exercise other duties and functions as authorized by Section 1. After that initial 15-day state of disaster emergency, if the disaster is extended either by the legislature when you guys are in session or by the Legislative Coordinating Council when you're not in session, and the governor determines it's necessary to exercise the powers conferred in Subsection C, then the governor may make application to the Speaker of the House and the Senate President when the legislature is in session, or to the Legislative Coordinating Council when the legislature is not in session, to extend authorization to exercise those powers. Subsection G provides that prior to issuing one of those orders, as authorized by this section, the governor would have to submit that proposed order to the Attorney General, who again shall review for legality and provide an opinion to both the governor and the Legislative Coordinating Council within 24 hours. Subsection H allows the Board of County Commissioners to adopt a less stringent order related to public health of humans that's not related to the food supply. That is very similar to the provision that is already in current law, just making a slight change to describe those public health orders. If a Board of County Commissioners adopts a less stringent order, then that order would operate in the county in lieu of the governor's order. Subsection I allows a party aggrieved by an executive order issued pursuant to this section to file an action in district court. The court would have to conduct the hearing within 72 hours and would be required to grant relief unless the court finds such order is necessary to achieve an important interest related to the state of disaster emergency and is substantially related to that interest. If an order does have the effect of substantially burdening or inhibiting the gathering or movement of individuals or operations of a religious, civic, business, or commercial activity, then the court would be required to grant that request for relief unless the court finds the order is narrowly tailored to respond to the state of disaster emergency and uses the least restrictive means to achieve that purpose. Section 6 amends KSA 48925B to provide that an executive order issued by the governor and affirmed by the State Board of Education that has the effect of closing schools or school attendance centers may only affect the operations of schools under the jurisdiction of the State Board of Education and shall not apply to private schools. New Section 7 is a severability clause, providing that the legislature intends the provisions of the act to be severable, and any portion declared invalid shall not affect the other portions that can be given effect without that invalid portion. If passed, this bill would become effective on publication in the Kansas Register. And I can take any questions.
Questions for Natalie? Representative Schreiber.
Thank you, Mr. Chairman, and thank you, Natalie. On page 1, the phrases on lines 23 and 24, do we add that kind of language in any other actions taken by the governor or legislature? They seem kind of implied when we are sworn in and so forth. It just seemed kind of odd the way they were stated, but I didn't know if that's a common phrase that's included in such things.
Mr. Chairman, I'm not sure. I would have to look at other statutes to see whether that exists. That language does exist in the current version of some of the KEMA statutes in KSA 48925. The changes that you guys made during the special session added that language, but before that time, I would have to look to see if there were other examples of that in statutes.
I have one more question. On page 2 then, Section F, can parties do that now? Can they, if they are aggrieved, can they go ahead and file action in district court? Or do we
Mr. Chairman, I am not aware of anything that would prohibit a party aggrieved by an executive order from filing a petition in court. On the other hand, I'm not aware of anything that specifically grants that in current law, but I'm not aware of anything that would prohibit a person from doing that now.
Okay, thank you.
Representative Carmichael.
Thank you, Mr. Chairman. Following up on Representative Schreiber's very valid concerns and considerations, separate and apart from any statutory authority that the governor may or may not have to act to protect the public welfare in times of emergency, does the governor have powers under the Kansas Constitution to act with or without the legislature's consent in times of emergency to save life and property?
Mr. Chairman, I would have to review those provisions a little bit more carefully before I would feel comfortable giving an answer to that question.
And Mr. Chairman, I would also feel equally uncomfortable answering that question, but I think it would be wise if we requested some fairly quick research from Kansas Legislative Research Service regarding what, if any, authority the governor may have separate and apart from statutory enactments to act in times of emergency, because I suspect the governor does have constitutional authority, and I also suspect there's nothing that we can do to limit that short of a constitutional amendment. Thank you, Mr. Chairman.
I agree. Let's see what we can get in the next day or so. Representative Hoheisel.
Thank you, Mr. Chair. Thank you, Natalie, for breaking that down for us. My question is on page 10, line 36. Well, it starts at 35. Except as provided in paragraph 2, the court shall grant the request for relief unless the court finds an executive order is necessary to achieve an important interest. What necessarily defines an important interest, and who determines that?
Mr. Chairman, for the that's kind of a legal standard that we use that we often refer to as intermediate scrutiny. So for the benefit maybe of the non-attorneys, there's kind of 3 types of tests we use. Then we use a rational basis test, an intermediate scrutiny test, or a strict scrutiny test. So if you look at the language in starting at line 39 in paragraph 2, that is more of a strict scrutiny test. We require it to be narrowly tailored to achieve a compelling government interest. This standard is more of a kind of in the middle type of test. It has to be an important interest and it has to be substantially related to that interest. But that is something that the court would determine. So if a party were to bring an action, the test that they would have to say is we're required to grant this person relief from this executive order unless we can make a finding that the order is related to that important interest dealing with the disaster emergency, and that this particular order and the effect that it has on this individual is substantially related to achieving that interest.
Thank you, Natalie. Thank you, Mr. Chair.
Representative Keither. Can you hear us, Representative Keither? We will come back to you if you can hear us. Representative Jennings.
Thanks, Mr. Chairman. Couple questions. Natalie, would you refresh the committee's recollection of the positions that make up membership in the Legislative Coordinating Council?
Yes, Mr. Chairman. The Legislative Coordinating Council consists of the President of the Senate, the Majority Leader in the Senate, the Minority Leader in the Senate, and then the Speaker of the House of Representatives, the Majority Leader in the House of Representatives, the Speaker Pro Tem in the House of Representatives, and the Minority Leader in the House.
And throughout this bill, when action is contemplated to be taken by the Legislative Coordinating Council, is this what you might describe as a delegation of legislative authority otherwise? In other words, where these things that the legislature as a whole would have the ability to do, and we're just telling them when we're not here, you do it? That makes sense?
Yes, Mr. Chairman. The issue of whether this constitutes a delegation of legislative authority is a pretty big one. That's a pretty big question. There's a lot of case law that we have related to that topic. But yes, what this bill purports to do here is take, when you're not in session, when you're in session, the legislature has the ability to, by concurrent resolution, extend a state of disaster emergency. They can terminate a state of disaster emergency or require the termination of a state of disaster emergency. And they can pass a concurrent resolution to revoke an executive order. And so when you're not in session, what this bill would do is allow the Legislative Coordinating Council to take similar actions.
Is the Legislative Coordinating Council required to be in Shawnee County when they take action?
I would have to review their statutes, but I am not aware that they are required to be here to take action.
So I take it then that the actions that would be taken by the Legislative Coordinating Council do not fall under the provisions of the Constitution that require us to be in Shawnee County, Kansas to conduct business. Would that be fair to say?
Mr. Chairman, the constitutional provision, and this again is, as you all are aware, there was an Attorney General opinion issued as to this topic. It's not as black and white as we all might hope that it would be. But the constitutional provision talks about the legislature and what the legislature where the legislature is required to be to take action. It doesn't call out specifically, at least, committee action, and the Legislative Coordinating Council is a committee.
Yeah, okay, so I follow that. Let's just say for the sake of argument that one of these executive orders comes up and LCC needs to do it, but if you wanted to have an option where it wasn't just the LCC doing it, maybe you had the legislature doing it, would the legislature be prohibited from your understanding of the Attorney General's opinion, from convening in a remote fashion to pass judgment on any of these kinds of things, should they come up and need immediate attention? I don't think they're the same as like passing laws exactly, so isn't this more of an administrative oversight function of the legislature on the executive as opposed to law passing?
Well, so a couple of things. The legislature meets during session. They can meet during a special session, which is called by the governor or by 2/3 of the legislature. So, whereas the Legislative Coordinating Council meets year round at the call of the chairperson of that council. So calling that meeting would be a little bit different, but as to whether the action that you're taking is lawmaking action, that is, again, a complicated question that I'm not sure I have a great answer for you today.
Well, I'll get less complicated then, I'm sorry. But I just think these are questions that maybe ought to be considered in all of this. So when you talk about, in the language that's used in here, is the same or similar disaster, that just strikes me as being somewhat broad. And I know that we tend to sit here today thinking in the context of what we've experienced the last 12 months. But there could be any number of scenarios that could play out, maybe even this thing, where you go for a period of time and it seems like, oh, we're done. And a month later you figure out, whoops, we're not done after all. But it's the same or similar thing that's occurring. So are they then prohibited from doing anything about it because it looks the same, it sounds the same?
Mr. Chairman, the language that's used there is what Representative Jennings read off. The only, you could provide a more detailed list of what makes a state of disaster emergency the same or similar, but without that, the only way we would really be able to know that is if the governor attempted to issue a new state of disaster emergency and then that action was challenged in court, and then the court would tell us whether that's the same or similar.
I mean, you're past your 2 already, so just keep going. You're on a roll.
I'm on. The chairman says keep going, so I'm going to just keep right on going. I'm curious about whether or not any of the powers conveyed in any of the existing law or under this proposal take into account size or scope of the emergency. And I'm getting to, you could have an emergency declaration that relates to a single county versus one that relates to 50 counties versus one that relates to 105 counties. So I guess the question is, does the scope or size of the character of the emergency have any implication for how they are managed and what's required to be done?
Mr. Chairman, throughout the Emergency Management Act, you'll see reference to the fact that a governor can call a state of disaster emergency for a localized area. And so there aren't any specific provisions, if it's just a disaster in this part of the state, then this is how you go about extending it, or this is how you go about getting those powers. We don't really make any of those distinctions here.
So under this scenario that's laid out in this bill, if there was a need for executive orders that go beyond 1 through 10 or whatever the magic number is, then that would trigger the need of the Legislative Coordinating Council to become engaged about those for maybe every disaster that might be declared for any number of reasons, floods or tornadoes or whatever.
Well, Mr. Chairman, I believe the way this would operate is, let's say the governor issued a state of disaster emergency just for Reno County because of a tornado or something. Then that disaster, since that proclamation is limited in scope, if the governor did decide that she needed to exercise a power outside of 48.925 1 through 10, then when she would come to the Legislative Coordinating Council, that would be part of that discussion. I think like the area of where that would be.
And last one, there's reference in here that makes me think that executive orders would no longer be enforceable as a crime unless the conduct itself would be criminal absent the executive order. Have I got that right?
Well, Mr. Chairman, and you might recall this from the special session, before we started making changes to this act, violations of the act were criminal. They were misdemeanors. And so you guys did make some changes to that. You made violations of the act civil. They carry a civil penalty. And so the prohibition here would be, say an executive order tried to say, oh gosh, something that tried to make legal something illegal, something that was otherwise legal. You can't, it's a crime to take your water bottle into a park. I don't know. If they tried to do that, then that would be in violation of that provision because it's criminalizing conduct that is otherwise not criminal.
Right, okay, so just one quick example. Let's think about Greensburg, Kansas, and the ability on one day to walk around the streets freely and wherever you wanted to, whenever you wanted to. And the next day following a tornado that levels that community, an executive orders entered that restricts people from being on the streets during the hours of darkness to preclude the potential of looting and those kinds of things. Enforcement of that as a civil matter strikes me might put law enforcement in a rather awkward position of being able to enforce the parameters of keeping people out when they really ought to be kept out. Because I think the power when it is a crime to violate a particular order is that law enforcement can take action on crimes that are being committed in their presence, such as going beyond the yellow tape and going into an area of disaster for which some restriction has been placed. Is that potentially a problem with this kind of language? Do you know?
Mr. Chairman, I mean, as to whether it's a problem, that's for you guys to decide. But right now, as the law currently exists, if you violate an order that's issued under this act, it's enforced civilly. That is the way the current law is after you guys made those changes in during the special session.
Representative Keither is back online. Did you have a question, Representative?
Hold on a minute.
Okay.
Yeah, I do. See if this, I'm getting feedback. Is it really awful?
You sound great, Representative.
Okay. Well, I'm using two computers, so it's a little crazy right now, trying to get to be able to talk. But I had a question in section small g, line 6 through 12, which talks about attorney general opinion. And my question is the opinion binding?
Mr. Chairman, the language with respect to the Attorney General providing that information, it would just be an opinion as to the legality provided both to the governor and the Legislative Coordinating Council. The Attorney General, as this bill is proposed right now, would not have the authority to stop an order from going forward or to say, I think this order is not legal and so it can't move forward. That is not contemplated here.
Okay, that's what I wanted to know. Thank you very much.
So we've got Representative Schreiber, then Carmichael.
Natalie, just out of curiosity, I could not find it, but maybe I'm sure you could. It's on page 2, line 41. There's a reference to KSA 48924 F2. I don't see an F2. Should that be 925 F2? Is it's updated later in the bill?
Yes, it should. And thank you, Mr. Chairman. Actually, the chairman pointed that out to me earlier. So that is, it should be a reference to KSA 48925 F2.
Okay. Second question, and then we can go to Representative Carmichael, is on page 10, lines 14 through 15, where we talk about they can, about the emergencies related to food supply. Is this trying to accomplish what was said in 48924 B2, where it talks about quarantine or other regulations to prevent spread among domestic animals, so on and so forth?
Mr. Chairman, those two provisions aren't really related. Let me try to explain. So right now in KSA 48924, the governor issues a state of disaster emergency. If that state of disaster emergency is related to quarantining domestic animals, then there are different provisions to allow the extension of that disaster declaration. Those extensions are handled separately. We are removing those provisions. And so now any disaster would be treated the same way, except we are retaining the provisions specific to drought disaster emergencies. But just a normal state of disaster emergency, they would all be treated the same way, no matter what they are covering. The language here on page 10 is more targeted to, so right now, if the governor issues an executive order, if it's related to public health, the Board of County Commissioners is authorized to adopt a less stringent order that would apply in their jurisdiction. But this limiting language that we're adding is saying that, say the state of disaster emergency that we were in was related to the food supply chain. If that was the case, then the Board of County Commissioners would not be allowed to issue an order for their county that was less stringent.
Are restaurants or what would be considered food supply?
That's a good question that I think we would need to analyze.
Okay, thank you. Thank you, Mr. Chairman.
Stump the reviser, Representative Carmichael.
Thank you, Mr. Chairman. I would advise or observe that our reviser is clearly extremely knowledgeable on these topics, and she ought to be complimented for her work, not only here today, but her work in drafting this legislation. That being said, I have a happy announcement for the committee that general orders are out, and for once it appears that we have drawn a bye for tomorrow morning, and if ever we needed a bye, tomorrow morning would be a good time for us to have one. I was not privileged to serve on the Joint Special Committee this summer, and I best leave it at that, or my leader will sanction me. So I don't have as much knowledge as some of you have, but after listening to Representative Schreiber's questions, as well as the very insightful questions of the judge from Lakin, I would think it might be wise for the committee, one way or another, to request some additional work by either legislative research or the reviser's office. First, with respect to the delegation of power to the Legislative Coordinating Council, there is a body of law out there, and I think if all of us had a common set of research, limited though it may be on that subject, it might help us make a better decision. There is also, of course, an Attorney General's opinion concerning when and where we can meet. Not all of us necessarily have that opinion, and it might be helpful if that could be provided to the committee. And finally, there are provisions in this bill that discuss action to countermand, if you will, executive orders which may have been approved at one point, but to then countermand those orders by means of joint or concurrent resolutions of the legislature. And while I think I know the outcome here, the doctrine in State Ex Rel Stephan versus Kansas House of Representatives concerning legislation, if you will, by means of joint resolutions might be applicable, and perhaps a little bit of research for all of us on that point and those concepts might also help us get to a better decision sooner rather than later, particularly in view of the severability clause that's contained in this bill. We want to try to do it right if we can. Thank you for your attention to my requests and concerns.
We will, I say we means not me, but the good people that help us will work on that. Other questions at this point in time, committee? Again, we will have this chance to continue asking Natalie questions along with the conferees tomorrow. So I don't see any other hands up in person. Don't see any online. So we will pause this hearing right now. We'll pick this back up tomorrow. Hopefully we have a lot of people listening at home and they're giving us advice via testimony so we can review that and hear from them tomorrow. I will keep you posted what the status of this bill is. If you followed along with anything else going on in the building today, the Senate yesterday introduced Senate Bill 273. I would encourage you all in your spare time to begin reading that. It's different than ours. There are some things that actually came up today. For example, Representative Jennings asked a question about a subsequent disaster. They do outline what that is, and so there may be, not implying there's not good stuff in here, but there may be some good stuff in there that we just need to look at. So I encourage you to look at that. They had a hearing today. They're having a hearing tomorrow, and according to Twitter, they're working their bill tomorrow. So we'll see where we're at tomorrow and or Friday or maybe early next week. We'll just keep talking about that and see where things go. That's it on 2416 for the day. Let's get started working some bills. Natalie and Jason, where's Jason at? There's his face. Are we ready on the DUI bills?
Mr. Chairman, I think if it's okay with you, we might prefer to hold just to make sure. Jason and I have been trying to talk about that back and forth really quick, but just to ensure that we're ready.
Just 2377. We're okay with 2378? Or you don't?
I don't know.
We'll skip them both, and if as you guys communicate, let me know when we move down the list if we find out we're ready. So let's start off with a good one, 2126. Might as well jump right in.
Mr. Chairman, sorry, give me just a second. Switch gears here.
And I apologize for not reading my text messages, Natalie. You told me to hold on
That's
to DUI
okay.
bills.
Mr. Chairman, House Bill 2126 provides immunity from civil liability for COVID claims for adult care facilities. You'll recall we expanded the definition of an adult care facility, changed their provision from an affirmative defense to immunity from liability, and then we took some of those requirements away that were otherwise required to meet to be able to obtain that liability protection. And I can take any questions.
Hey, Natalie, do we have the amendments ready on this one?
I believe we do.
Okay. So questions for Natalie on the bill? I don't see any. So on amendments, Representative Ralph?
Yes, Mr. Chair, thank you. I have an amendment. Natalie has those to present.
And Mr. Chairman, if Representative Ralph sees this and does not think that it's ready, he can feel free to let me know.
to wait just another moment because some of this amendment presents a little bit of a challenge to read the way it comes up there. So I'm going to wait a second until you get that into your emails for everybody.
It just hit my inbox.
I'm going to take my cue from my wife saying that normally you watch to see people's heads come up from reading, so I'm going to wait to speak until I see a few heads come up. Yeah, I am seeing several heads, Mr. Chair, if I might go ahead and I'll walk through some of these and then mainly take questions on this if I don't hit all the specific spots. Starting at the top of page 3, you'll notice the first item here is a striking of the administrative fines or penalties from this particular immunities provision portion of the statute from the original language. Then there's a significant amount of stricken language from the original proposal, but what we've included in there is it appeared that biggest part of the concerns was the extent to which this might be referred to as almost a blanket immunity in the original language. The language that we've now included in here provides that the facility was in substantial compliance with public health directives applicable to the activity giving rise to the cause of action when the cause of action accrued. This language is similar to other language we've used in other parts of the act under the, was it 605501 through 605508. So it's similar language used in that regard, although there is stricken language that the facility we struck out acting pursuant to, and the language now just reads if the facility was acting in substantial compliance with public health directives. From there, we've also changed for this specific section the definition of public health directives, and specifically the change was we removed executive orders as being a part of public health directives in relation to this. Out of the concern that some of the executive orders in this particular matter had to do with congregant care situations or congregant gathering situations, and didn't want to get caught up in that piece of it. So we have made a specific change there. Keep in mind, we defined public health directives at the beginning of this particular act. So this is a change within the act, again, for that the use of that particular language defined in there. And that's the bigger bubble that you see at that point in time. So with that, what I've attempted to do here is to remove some of the sense of the blanket immunity, but keep it in line with the immunity that we have provided in other sections of this. It's not the same, because obviously through all those different sections, we've got immunities here for healthcare providers, we've got the nursing homes, we've got product liability, we've got the business exception. So we've got several sections dealing with immunity. We don't have exactly the same language through all those, but we've brought this closer to the language that we have used in relation to the other items for immunity. I'm going to stop talking at that point to answer any questions that people specifically have as they look at them.
Let's get your amendment moving.
I move my amendment.
Is there a second? Representative Schreiber? Discussion on the amendment, Representative Carmichael.
Thank you, Mr. Chairman. My compliments to the Vice Chair for his good work. This is a substantial improvement over what we originally saw. Because of the way our legislative process works, I don't have the luxury to read and think about this overnight and confer with true experts to know whether I would be able to support the principal bill on the floor were these amendments adopted and placed on the bill. And so reserving the right to flip-flop for the time being, this appears to be good work by our Vice Chair, and pending further discussion of the amendment, I intend to support it. Thank you, Mr. Chair.
Representative Owens.
Thank you, Mr. Chairman. I guess being online has its benefits. You get to see my hand
I
raised.
did. I'm like, whoa, he's here and raising his hand.
Representative, can you tell me whether the industry was consulted in all of this? I mean, is this a product of your own, or have you worked with all the parties involved in this?
It is a product of my own. I have worked with several parties, but I would not describe for you that this has been and when I say everybody, talking about all potentially interested stakeholders, but I have been in conversation with the industry, correct?
Okay, and a follow-up question. To me, the way that B was written is very plain languaged. When we move to, when we strike B as it is in this amendment, it doesn't seem like what was written in the larger box. I understand the top of it. It doesn't seem like what was written in the larger box does the same thing or substantially the same thing as it relates to shall apply to any claim for damages or liability that arise out of or relate to acts of omission related to the COVID-19 public health emergency. Help me understand that box does substantially the same thing, or maybe it doesn't.
Mr. Chair, if I might, help me find the spot that you're referring to, because we've got some small b's and some capital B's. And
So I'm looking at page 3, line 21 through 23 that has been stricken.
Mr. Chair, if I might, and some of this is whirling by me. Natalie, is that the item that you had pointed out to me that was a concern as a duplication and we removed it?
No, Mr. Chairman, that was a different item. And so I think what Representative Owens is asking is whether this big box kind of replaces B, and it does not. And so those aren't similar at all. We're just adding a new definition section. And so the way the section would read is, notwithstanding any other provision of law, an adult care facility is immune from liability in a civil action for damages for a COVID-19 claim if the facility was in substantial compliance with public health directives applicable to the activity giving rise to the cause of action when the cause of action accrued. And then we have the provision saying that the immunity does not apply in instances of gross negligence or willful wanton misconduct. And then we have that definition for the public health directives.
All right, thank you for that clarification. I'm going to reread this the way that you did with a different understanding of what it actually does. So thank you. Thank you, Mr. Chairman.
And I apologize because the big box is completely new language because we redefined, in essence, public health directives from the original the still existing definition that's at the very beginning of the act.
Representative Schreiber.
Thank you, Mr. Chairman. I think I've spent too long in judiciary. I'm starting to think like an attorney or something, but
Welcome to the club.
I need a shot. The big box, Is there a chance that someone might question if it was executive order or something like that, that's not specifically a state statute or rule or regulation, that might not be captured in there?
Yes. They might not guess that it is not captured in there. An executive order is not captured in this definition.
And should it be?
No. I mean, that sounded too blunt. That was not my intention in the drafting of this. It was my intention to remove executive orders for the concern that, for example, in this, some of our executive orders deal with congregant situations or gatherings, which just, to my mind, that was a concern in regard to what actually occurs in nursing home situation. So it was my intention to remove executive orders from that particular definition in relation to obtaining the immunity.
All right, thank you.
Representative Carmichael.
Thank you. In further support of our vice chair, another good reason that we may not want to include executive orders is, as we know from our last discussion, they are somewhat fluid, uncertain, subject to change, and it would place a moving target for the industry to try to meet were we to include them. So just my thoughts. Thank you.
Representative Owens.
If I might, thank you, Mr. Chairman. After saying my comments and recognizing the sheer number of people that are involved in this conversation, and also those listening online have reached out to me to let me know that indeed the industry does agree with this language change. And that is helpful just for context. And I wanted everybody to know, since I asked that question earlier, that is indeed the case.
They're all sitting here and you can't leave the room without walking by them. Further discussion on the Ralph amendment? Not seeing any. Representative Ralph, you may close.
Thank you, Mr. Chair. And just as a brief comment, just so that the representative, it wasn't my intention to be coy. We just had never specifically had that with the industry, a specific conversation of approval. And so I didn't want to get out over the end of my skis there at that point. I close, Mr. Chair.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. Further amendments? Representative Hoheisel.
Thank you, Mr. Chair. I do have an amendment.
Natalie, do you want to send that out, please?
Yes, Mr. Chairman, let me.
Mr. Chair, if I may start, well.
Sure. Go ahead.
My amendment's rather simple. We heard from both IDD providers and community mental health crisis centers about them not being covered under this. So my amendment just folds them into this as well.
Okay, just hit my inbox. All right. Pull it up and begin reading it.
Mr. Chair, I'll move my amendment.
Okay, and we have a second by Representative Samsel. We will go ahead and move to questions or discussions with Representative Carmichael.
Thank you, Mr. Chairman. Sadly, I must oppose this amendment. This represents a substantial expansion of immunities. And while I personally respect some of my friends who asked for this relief in their testimony, there is no explanation, a meaningful explanation as to why community mental health centers and community service providers should be given immunities and protections beyond those of Main Street businesses. I understand they want it. And I understand when they say, I just found out that my general liability insurance policy doesn't cover infectious disease. Well, I hate to tell you this, it never has. There is a different type of coverage that's available to healthcare providers that does cover infectious disease, because infection control is an inherent part of good medical care. And I'll be honest with you, when I heard people say their premium had only gone up by 10%, I was astounded, because I can tell you the price of a hamburger at McDonald's has gone up a lot more than 10%, principally because of the COVID crisis. Go to the grocery store, go anywhere. Prices of everything are higher now than they were a year ago, and COVID had a lot to do with that. And so, you know, the IDD community and the mental health community, the mental health center community, and by the way, these folks aren't here on behalf of the people who receive the services, the people who live in these congregate living settings that Representative Ralph was talking about. No, these folks in many instances are large for-profit corporations, but they have not made the case as to why they should have protections that are not available to Main Street business. And doing this in a circumstance where you don't have the Center for Medicare and Medicaid Services actively involved, where you don't have CDC standards, where you really don't have the types of things that Representative Ralph put in the amendment, is dangerous for the people that live there. The proposition is unfair. It's picking winners and losers, one business over another. And although I know the representative's intent was good to try to accommodate the requests of people who came before the committee, I'm assure you, if we reopen the hearing on this amendment about IDD and community mental health centers, you will hear substantial and very good opposition to this idea. So I don't believe that this is the time to favor these organizations over others. Thank you, Mr. Chair.
Discussion committee? Representative Owens?
I think that this raises a very valid question, and it's a similar question in some ways to the question that was asked when we debated this bill, because if you'll recall, there was plenty of opposition to this bill to begin with, and it appears like we've made some progress in the right direction. But the question is, for example, does a community mental health center provide health care? And if so, why should it not have the same protections that every other healthcare provider has? Does a crisis intervention center provide health care? That I do not have as much of a clear answer on. And if so, should it have those protections? So I would just ask the committee to consider that these are, in my opinion, they provide some level of healthcare service and is therefore justified to have the same protection as other healthcare providers. And I certainly welcome any comment or thoughts along that line of thinking.
Representative Samsel?
I could not agree more, Mr. Chairman, with the previous speaker, except that I would say that our mental health care centers are absolutely providing health care services. And in fact, some of the most vital I mean, some of the testimony I've heard out of Southeast Kansas and the areas where we represent, my goodness, I can't think of more compelling circumstances to help these folks out right now. So I do understand and often agree with the distinguished lawyer from Sedgwick County, but this is not one of those times. So I appreciate the representative who did all of the work to bring this motion. Strong support, look forward to working forward on the other issues that do remain.
Representative Jennings.
I wonder, can I inquire of Natalie a question to go to her?
I heard in corrections today that you can always inquire of Natalie, so.
That's the rumor. That's the rumor. I'm curious, Natalie, are you able, based on your work with all of these things, to tell us specifically the various entities that have gained some level of immunity through this? I mean, I know about hospitals, for instance. Do you know offhand what that laundry list looks like?
Mr. Chairman, so in the COVID Response and Reopening for Business Liability Act, we have separate provisions for healthcare providers, businesses, products liability, and adult care facilities. And so healthcare provider is defined as a person or entity that is licensed, registered, certified, or otherwise authorized by the state of Kansas to provide healthcare services in the state, including a hospice. Healthcare provider does not include any entity licensed under Chapter 39. So that's kind of the adult care home portion. And so this bill, you'll see the changes that you guys are proposing to make to the definition of an adult care facility. But we have businesses generally, products liability, adult care facilities, and healthcare providers.
So would a private prison or private jail operating within the state of Kansas that provides healthcare services to its inmates enjoy the same immunity that a healthcare provider would otherwise?
Well, okay, so a healthcare provider. So I guess there's two routes that we have to think of there. And that's why, I mean, there is a little overlap here because say, for example, in that, in the example you just gave me, a private prison is probably actually a business as well. So they might fall under the business portion, but the healthcare providers themselves are immune from liability regardless of where they work. The healthcare provider one talks specifically about the providers themselves and the facilities. So there's kind of a two. So if a nurse provides care at a private prison, that private prison might be immune under the business provision. I'm not sure. I'd have to kind of look at that further. The nurse herself or himself would qualify for that healthcare provider immunity as well.
Healthcare provider definition is medical healthcare provider.
Mr. Chairman, you'll see the definition of a healthcare provider it starts on page 1 at line 35. So it's a person or entity that is licensed, registered, certified, or otherwise authorized to provide healthcare services in the state.
Thank you.
Representative Samsel.
Thank you. Natalie, help me understand. This may be a bit of an unfair question, but Elizabeth Layton Center is a mental health facility, and I'm actually just looking at it online here, but they serve Franklin County and Miami County, both in my district. And a quick shout, Elizabeth Layton was affectionately known as Grandma Layton before she passed in Wellsville. She'd been in our area for a very long time, known for artwork that she'd done and sold across the country and world to help raise awareness and funds for mental health. But the practical import of this bill, I believe, is, and I agree with the representative from Sedgwick County. I don't like picking winners and losers either, and to some extent, that's what we're doing here. But without this amendment, the Elizabeth Layton Center will not have this added protection, which I understand other healthcare providers will have. Is that a fair question? I know you're probably not familiar with Elizabeth Layton Center, but it's essentially, it's a not-for-profit community health center.
So yeah, I don't know anything about that center. I don't know anything about the services that they provide, but if they are a entity that is licensed, registered, certified, or otherwise authorized by the state to provide healthcare services, then they would fall under the healthcare provider provision. There is also an argument to be made that they could already, they would fall under the business provision, which that provision is not in the bill, so you can't see that there, but it's KSA 5504, which provides that notwithstanding any other provision of law, a person or an agent of such person conducting business in the state shall be immune from liability in a civil action for a COVID-19 claim if such person was acting pursuant to and in substantial compliance with public health directives applicable to the activity giving rise to the cause of action when the cause of action accrued. So that's a pretty broad immunity provision for anyone conducting business in the state.
Thank you, Natalie. I guess, Mr. Chairman, my thought is that by passing this amendment, it removes any doubt as to whether the Elizabeth Leighton Center and others like it are covered within this same protection, rightly or wrongly, winner or loser. So that's why I stand in support of the amendment, among other reasons. Thank you, Natalie. Thank you, Mr. Chair.
Other discussion on the amendment? Representative Heiberger.
Yeah, I just point out that the Elizabeth Leighton Center is a community mental health center as defined in Section 2 in the amendment.
Very good, thank you. Any other discussion? Seeing none, Representative Hoheisel, you may close.
Thank you, Mr. Chair, and thank you, committee, for this discussion. I think that's really good discussion on this, and with that, I close.
For the motion, all in favor say aye. All opposed say no.
No.
The ayes appear to have it. The ayes do have it. The amendment passes. Any further amendments? Representative Samsel, is your hand just still up, or you've raised it for the, okay. I don't see any other amendments. What's the pleasure of the committee on 2126? Representative Owens.
Thank you, Mr. Chairman. I motion that we pass House Bill 2126 favorably as amended.
Second by Representative Hoheisel. Discussion? Seeing none. Representative Owens. Hold on.
Mr. Chairman, I'm sorry.
Oh, you're fine. Representative Carmichael.
Thank you. Thank you for your indulgence, Mr. Chairman. I'm sorry, Representative Owens. I know you were in a hurry to get this across, but just give me just a moment. Seriously, the bill has been improved, but we are still overlooking the basic premise that none of this is really necessary. You might recall that during debate of this during the hearing on this bill, I provided Mr. Maloney with instructions that are routinely given to juries in this state regarding the standard of care that is applicable to healthcare providers, that's applicable to professionals, and that's actually applicable to you and I. And the overlying premise of tort law is that we are responsible for the damages that we cause to others only when we fail to act in conformity with the standard of care, if you will, that is applicable to the professional in the community in which they work and under the same or similar circumstances. You know, our system of civil justice is actually older than our republic, because the concept of the right to sue for damages and the concept of personal and professional responsibility had its origins in the English common law. And it has been tested, tried, and true in multiple circumstances. And no jury in the world, no judge in the world is going to ignore the fact that we have been in a pandemic for the past year, and that things that were available to us before or after the pandemic were not available at the time. And so as we continue to carve around and make exceptions for this group or that group who come to us and some who have stronger lobbyists than others. We mess with a basic principle of our country, and that is that we're all responsible to act reasonably, to look out for the safety of others, to either do not do or fail to do that which a reasonable person would do under the same and similar circumstances. So this entire activity, in my judgment, is unnecessary, and accordingly, I will be voting no on on 2126, despite the improvements that have been made by my friend the Vice Chair. Thank you, Mr. Chairman.
Senator Samsel.
I would just very briefly, Mr. Chairman, point out that I actually agree with the prior speaker that this was a can of worms that I never liked opening to begin with. But I think, as he just said, this is an improvement. So that's why I support it today. And with that, I will be quiet. Thank you, Mr. Chair.
Seeing no further discussion, Representative Owens, you may close.
Thank you, Mr. Chairman. And I might just add, since there have been previous comments, that the great legal mind of the past representative and his comments, while I think that there may be validity to his argument, I would also say that his argument has not stopped the lawsuits that have already begun. And two, by passing this legislation, 3, well, that's all right. There could be 28 by the time we're done talking. The reality is the CEOs and those working at our adult care facilities, our CMHCs, our IDD facilities are going to sleep a whole lot better at night knowing that these, well, that was fun, knowing that these protections are in place and that our state cared enough to spell this out in plain language to ensure that they have the protections necessary that all other healthcare providers are afforded. And I, for one, am grateful for the opportunity to stand here to protect them, and I move my motion.
For the motion, all in favor say aye. All opposed say no.
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 The ayes have it. Motion carries. Those wanting their affirmative votes recorded, Owens, Hoheisel. The negative votes wanting recorded, Carmichael, Heiberger. I believe that appears to be all I'm seeing. Let's move on to 2153.
Sorry, Mr. Chairman, let me,
Or you could just give me whichever one you're ready for, Natalie, and we'll work the order you prefer.
no, that's fine. I kind of miss having my folders there. House Bill 2153 increases the criminal penalty for mistreatment of a dependent adult or elder person when the victim is a resident of an adult care home. And I can take any questions.
Any questions for Natalie? Are there any amendments? It's the pleasure of the committee on this one. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2153 favorably.
Is there a second? Representative Burris, discussion? Seeing none. Representative Hoheisel, you may close.
Close.
Heard the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. Those wanting their affirmative votes recorded, Owens, Hoheisel, Carmichael, Ohabisam, and Heiberger. Let's go back up, Natalie. Let's do 23-7. No. That one could take a while. Let's just keep moving down the list, my list. 2264.
Mr. Chairman, House Bill 2264 would permit student athletes at post-secondary educational institutions to receive compensation for the use of their name, image, likeness rights, or athletic reputation.
Questions for Natalie? Are there any amendments? Not seeing any. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2264 favorably.
Is there a second?
Second.
Representative Samsel. Discussion, Representative Carmichael.
Thank you, Mr. Chairman. I do not intend to engage in a soliloquy over this bill. It will have terrible unintended consequences. Those who vote in favor of it will long regret their vote. Thank you, Mr. Chairman.
Representative Samsel, or you took your hand down? Any further discussion? Seeing none, Representative Hoheisel, you may close.
I close.
For the motion, all in favor say aye. All opposed say no.
No.
The ayes appear to have it. The ayes do have it. Affirmative votes, Hoheisel, Heiberger, not Owens. Okay, sorry, call you out for it. The negative votes, we've got Carmichael. And that's all I am seeing. Let's go to 2362.
Mr. Chairman, House Bill 2362 would modify the elements of the crime of abuse of a child. It would also change the structure for the criminal penalties for that crime.
This is the abuse of a child bill that we've actually had several versions of this, but this is the newest version. None of those, I can't remember if any of them moved out of committee, but they certainly did not get across the floor. 2362. Natalie, would you mind reviewing that one more time?
Yeah, it modifies the elements of abuse of a child, and then it changes the criminal penalty structure to match those new elements. And I can go into further detail if there are specific questions.
Any questions for Natalie? Do not see any. Do we have any amendments? Do not see any of those either. Representative Hoheisel?
Thank you, Mr. Chair. I move we pass out HB 2362 favorably.
Seconded by Representative Wheeler. Discussion? Seeing none. Representative Hoheisel to close.
I close.
Or the motion, all in favor say aye.
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 All opposed say no. Motion carries. The yes votes: Owens, Hoheisel, Heiberger, Burris, Neely, Carmichael, O'Habisam. Now let's go back up to 2377.
Mr. Chairman? House Bill 2377 revises the laws concerning driving under the influence of alcohol, including the reinstatement of a driver's license provisions for certain persons with an ignition interlock device restriction. It also requires persons with an ignition interlock device to complete that program before their driving privileges would be fully reinstated. It provides for reduced ignition interlock device program costs for certain persons. And then it modifies the criminal penalties for driving a commercial motor vehicle under the influence. And I can, well, Jason can take any specific questions probably if you have them.
Representative Carmichael.
Thank you, Mr. Chairman. I do have an amendment on either 2387 or 78 or 2377, and I know Ms. Scott is diligent and knows which bill it is that my amendment belongs on.
It is on this one, Representative Carmichael.
In that case, Mr. Chairman, I do have an amendment. While the amendment is being distributed to the community, to the committee, I would be happy to explain it if you wish.
Please do.
In, I believe, 2 instances, this bill imposes the responsibility on the Secretary of Revenue to adopt either mandatorily or permissively, and I think we actually, through the amendment, make sure that it is mandatory. New rules and regulations to implement the bill. There are also some existing references to rules and regulations that are in the current language. I don't believe that I touched those. But with respect to the new rules and regulations, the amendment imposes a date by which the secretary will accomplish this task. And it sets that date, I believe, 9 months following the effective date of the law, which will put us at the end of March next year. The reason that we do this is, and if the chair hasn't received it yet, I think you're going to receive a kind letter from the chair of the Joint Committee on Rules and Regulations suggesting to us that when we authorize rulemaking authority, that we realize whether it's broad or narrow, but also that we give careful consideration to giving a date by which it is to be accomplished. Sadly, we still have circumstances where laws that we have passed 5 and perhaps even 10 years ago, which call for rules and regulations, still have yet to be complied with. And so as a matter of policy, I think it's a good idea for us to try to include a deadline whenever we extend rulemaking authority. And that's what this amendment is designed to do. Thank you.
You'd like to move your amendment?
I certainly would, Mr. Chairman.
Thank you. Is
Second.
there a second? Second by Representative Keither. Discussion, Representative Samsel.
Thank you, Mr. Chair. Question, if I may, for the bringer of the amendment. What happens if they don't meet the deadline?
As a matter of fact, there's really no penalty. However, a motion, an action technically in mandamus would be appropriate at that point to compel the agency to act in accordance with the law. But it is our hope, and I think I can speak collectively for the Rules and Regulations Committee, that by placing goals, deadlines, whatever you want to call it, in the statute, that the power of public opinion and gentle persuasion will obtain compliance. And I have, in this particular bill, I have no concern whatsoever but what the secretary will promptly promulgate the regulations. But it's more a matter of policy that I hope we can try to apply going forward, because we've recognized on the Joint Committee that there are some agencies, not all of which are cabinet level, some are independent boards and commissions, who seem to be recalcitrant to complying with the legislature's wishes. Thank you.
Thank you. I appreciate that explanation. I get the point of making it mandatory. I'm wondering out loud a little bit if the deadline would not, though, if they're juggling other pressing priorities, if we're not, and I get that this date is a long time out there, but I guess maybe bigger picture, if we're imposing dates in there, if that causes some heartburn there, but I'll think about that some more on not the committee's time. Thank you.
Any further discussion? Representative Carmichael, you may close.
Thank you, Mr. Chairman. Just in brief answer, though, to that question, generally, rules and regs can get through in 6 months or even less if the agency puts its mind to it. And 9 months seems to be a reasonable time period to accomplish these things. And think about a bill like this. If you have to have rules and regulations to make it work, you don't want the agency to drag its feet for a year while bad things happen in the interim. So with that, I close and move my amendment.
Heard the motion. All in favor say aye.
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 All opposed say no. Motion carries. Further amendments? Representative Owens.
Thank you, Mr. Chairman. Hey, Natalie, did you get that email from me a little bit earlier today?
I did. I have your amendment ready, I believe.
Awesome. Thank you, Natalie. You're the best. So while that is being promulgated, this is a very similar amendment to the amendment that I carried a year or two ago when we heard a very similar bill in this committee. My concern here is, as I was reading through, this is going to be on page 21 of the bill towards the end, that we are carving out discounts for people that make 300% of the poverty level. I want everybody to understand what 300% of the poverty level is. For a family of four, that's somebody that's making just short of $80,000 a year is getting a discount after they've been convicted, when we all know that part of the penalty is the pay that you have to pay. What my amendment does is it steps down to 150% of the poverty level. So if you make 150% of the poverty level or less, you only have to pay half of the fee. And with that, that would drop it for a family of four, would get a break making $40,000 a year and not $80,000 a year. Again, we're working with these are private businesses that we're ultimately forcing to take a cut on this as a result of this legislation. And I think it's important that we take into consideration what true indigency is. And I think that we absolutely need to compensate for that, right? I think that when there should be some ability in this situation for people that can't afford it to pay it. But I just don't think that 300% is the mark. And I couldn't find anywhere else in state statute where we do anything similar to this at the 300% mark. Everything I found was at the 150% mark. So with that, Mr. Chairman, assuming everybody has received the amendment, I will move my amendment.
Is there a second?
Second.
Representative Humphreys with the second. Discussion, Representative Ralph.
Thank you, Mr. Chair. In starting these remarks, full disclosure, I chaired this particular committee out of Judicial Council, so if I raise my voice a little bit as I'm speaking, that's where that comes from in this. Because I'll also will say to the committee that this is not an area of practice for me, so I mainly just kept the folks that were involved between the lines and moving forward, and did some great work in terms of defense counsel, prosecutors, judges, as well as representatives from the Department of Revenue and law enforcement. So in any event, a couple of items here. Just as an initial piece of this, the initial statement talked about this being a part of the penalty, and I want to make sure that we're really clear. The payment for the IED and the installation here has nothing to do with penalty involved with a DUI. That's administrative procedures, and we take care of penalties with through the court in terms of fines and jail time and the like. So the IED is not part of penalty involved with, I'm sorry, Mr. Chairman. Sorry. Sorry, Representative.
You'd raise your virtual hand, that wouldn't be a problem.
Yeah. So in regard to this item, as Representative is correct, this committee heard this particular amendment the last time this bill was considered in the last session. Because of the length of time this particular committee met, then we were able to actually take that amendment back to the Judicial Council Committee since we were still meeting, and consider that because as I recall too, I think it passed through this committee. So we were able to the committee was able to take that back and give consideration to the discussion that this committee had in that regard. Also, as a part of that committee, we were able to involve the council on the ignition interlock manufacturers involved in these discussions. They were a tremendous assistance and help to us in providing this entire work product. So I want to commend them for the work that they did and the cooperation that they provided. But the committee heard that information, and still based upon that felt it was an important enough matter to retain in this sliding scale of discounts, the 300% as the top end discount. And the thing to keep in mind here is that 300%, anything between 200% and 300% of the indigency level provides a 10% discount. That's the top discount you can get at that level is 10%. And the sliding scale takes that down to folks making less can get larger discounts as we go along. Another piece to keep in mind is the price points on the ignition interlocks are within the control of the vendors. So right now, we were advised by the Department of Revenue that at this point in time, about 50% of folks who are required to obtain the ignition interlock device actually get it. Through this particular legislation, and if this bill passes, we absolutely expect, and between that and the compliance-based process, we expect that the use of ignition interlock devices will increase substantially at that point in time because folks won't be able to just wait out that 2-year process. In order to get a license back, they're going to have to show compliance, the installation and compliance. So at this point, I want to read just a couple of paragraphs from the report that was generated by the committee that I think sums this up better than some of the words that I would use here. The committee agreed it's essential to allowing all drivers required to use an IID to participate and complete the program. The committee's overall goal was to have as many people as possible use and successfully complete the program. The division estimates about half the drivers who fail to complete the required IID program do so because the financial cost of the IID. In order to enable more people to use and complete the program, the committee recommends that Kansas move from an indigency-based program, one that assists individuals who qualify for food assistance, to an affordability-based program, one which utilizes the sliding scale of payment based on the IID user's household income. The committee reviewed other states' IID affordability programs, structures, and received input from the Coalition of Ignition Interlock Manufacturers. What the committee determined was they recommended expanding those who qualify for the program to persons whose household income is up to 300% of the federal poverty level, with people with a household income between 200 and 300% of the federal poverty level would receive 10% discount from the ignition interlock provider. However, the committee agreed that even a small discount might serve to allow a hardworking single parent of 3 making $53,000 a year to successfully complete the IID program, thereby enabling that parent to internalize the separation between drinking and driving, as well as obtaining fully restored driving privileges. The significance of the installation of the IIDs is critical, and the overriding purpose for attempting to get these devices installed is to keep folks off the road and to separate their idea of drinking and driving. And anything we can do to increase that 50% is imperative. At this point in time, increasing what they pay for it doesn't put anybody's more skin in the game. They've already got skin in the game with jail time hanging over their heads. They've got fines hanging over their heads. And right now, the installation of the IID is simply a matter of if they do it, they can get back on the road. And if they don't, they won't get that license back. So I will not support the amendment. And obviously, I'll be supporting the recommendations of the committee. Thank you for indulging me, Mr. Chair.
Representative Heiberger.
I don't have a lot to add to Representative Rouse's explanation, but I would note that the amendment would double the cost of compliance for people at 100% of federal poverty level or below, for people on food assistance, child care subsidy, or cash assistance. I know from experience, people I know, that those fees are a barrier to making this work and to getting their license back and getting employed again. And so for that reason, I'll oppose it.
Further discussion on the amendment? Not seeing any. Representative Owens, you may close.
Thank you, Mr. Chairman. And the Vice Chairman makes some incredibly valid points. I don't discount that, and I certainly don't discount the work of the committee. DUIs are a serious, serious issue. And even though we like to sometimes minimize the misdemeanors that go on, DUI and alcohol-related issues are such a huge cause of death and familial issues. I mean, alcohol can be tied back to all sorts of things. With that being said, putting a structure in place to make sure it's affordable is important. I do totally agree with that. However, You've got to have some buy-in in a process like this. You've got to have some accountability in a process like this. The average ignition interlock is $83 a month. I just want to add that perspective. That's full payment is $83 a month. Even if you knock that in half, that's $40 a month. And I'm certainly not discounting the different levels of how important $40 or $80 is, but it's not like we're talking about hundreds and hundreds of dollars here. Once upon a time, I was in the ankle bracelet business, and you would pay $10 a day for one of those devices. So you're talking $300 a month. And I can get a structure like this in that scenario. But when we're talking about $83 a month to start, I think that it is reasonable that people have the buy-in if they make better than 150% of the poverty level. And with that, Mr. Chairman, I move my amendment.
Heard the motion. All in favor say aye.
Aye.
All opposed say no.
No.
Noes appear to have it. Noes do have it. We're back on the bill. Any further amendments for 2377? Seeing none, what's the pleasure of the committee on this one? Representative Owens?
Mr. Chairman, I just want to make absolutely sure that no one else has an amendment that they are interested in.
Not me, right? Nope, okay.
All right, am I good?
Yeah. Okay, everybody, nobody has an amendment.
Mr. Chairman, may I inquire if I have an amendment before the chair? I don't think I do, but if I do, I sure hope the revised will remind me. Okay.
Okay, what about Representative Ralph?
May possibly.
My battery's about dead. Come on, Natalie. Oh, no, well. She's calling somebody. Whose phone's ringing?
I think we have cookies or ice cream in our future.
Oh.
Mr. Chairman, I think the one I was thinking of is on a different bill, so I think we are good on this.
Okay, I don't think we have any more amendments, so Representative Owens, you want to finish?
Thank you, Mr. Chairman. Notwithstanding the failure of my amendment, I do fully support House Bill 2377 and recommend that we pass it out favorably from this committee as amended.
Is there a second? Representative Ralph, any discussion? Seeing none, Representative Owens, you may close.
I close, thank you.
You heard the motion. All in favor say aye.
Aye.
All opposed say no. The ayes have it. Motion carries. The affirmative votes being recorded: Owens, Oheisel, Heiberger, Carmichael, O'Hobson. Okay, committee, here's where we're at. We have 2387, which is the aircraft DUI bill. We could probably do it quickly. No, we can't. And then that would leave us the prosecutorial powers of the Secretary of State, and then the three maybes I gave you yesterday, which the immunity for the overdose bill we heard on Monday or Tuesday, and then 2389, which I don't remember what that one was. But why don't we? Let's see. And I don't want to rush, but let's do 2387, and that way, because I'm worried tomorrow we're not going to have any time, and then that means we're for sure here Friday to work just a bill or two. So let's do 2387 really quickly. Natalie.
Thank you, Mr. Chairman. House Bill 2387 revises the laws relating to operating an aircraft under the influence of alcohol or drugs, including prescribing criminal and administrative penalties and providing for testing of blood, breath, and urine or other bodily substances. It also includes provisions relating to the preliminary screening test of breath or oral fluid. And I can take any questions.
Any questions for Natalie? Before we begin discussing it, I would like to share that, let's see, Representative Carmichael, Representative Ralph, and I did receive an email from Steve Hitchcock, who was the aircraft individual that's, I can't remember what his organization is, Ag Aircraft Organization, and they opposed this the other day. I know Representative Ralph had visited with him, and he now indicates that worst case, they're a neutral. So, I mean, they're not concerned. Their concern was the legislature jumping into things that they think the FAA should regulate, but when it was explained to them why we were doing this, that they're no longer opposed to it. Are there any amendments? Representative Jennings.
Yes, I would like to call on a different reviser, maybe. Is there one available? The amendment will be distributed to you by someone down there. And I can begin to describe this real quickly. It's pretty straightforward. You'll recall there was some conversation about, people who aren't licensed, they're never licensed to operate an aircraft, and they're taxiing them around, and some of the particulars about how the FAA works on those things. So this amendment will make it clear that in terms of elevating the severity of the offense, that would occur in the case of people who were currently prohibited from operating an aircraft by virtue of an order entered for a prior occasion of operating an aircraft while under the influence, or at a time that their pilot's license is revoked or suspended by an order of the FAA as a result of a prior alcohol or drug-related conviction. It just cleans it up a little bit to make sure that we understand. It applies to those who shouldn't be doing it anyhow. They've been ordered by the FAA or the court not to even be behind the wheel. So.
Okay, so we've got a motion by Representative Jennings, a second by Representative Hoheisel. On to discussion, Representative Carmichael.
Mr. Chairman, hold on a minute. I think I may have distributed the wrong amendment here. So let me.
It's not mine, is it? Is it another one?
I was going to say, there were a lot of words in the one we just got. The second has been withdrawn. Should we wait to give Natalie and Representative Jennings a chance to make sure they're on the same page?
It's dated February the 22nd, 2387. There's no numbers on these otherwise, is there? Yeah, it is. It's going to be 2387 Balloon Jennings. You don't see it?
Yes, I have that. Sorry about that, Mr. Chairman. Jason actually drafted a lot of these since he wrote the bill, so I'm not as familiar with them here. Just here, let me get this one distributed.
Okay, so to keep things moving forward, we have a motion by Jennings. We still have a second by Hoheisel, and we have a new second. And why don't we go ahead and hear Representative Carmichael's question or comment while we're waiting on the language, unless he'd like to wait.
Oh, no, Mr. Chairman, we're making good progress. I don't want to stand in the way. But if I might inquire of the maker of the amendment, I know that upon first glance, when I looked at this statute, I also had concerns because I perceived that there might be sentence enhancement for folks who are not permitted to operate aircraft. And I think your amendment addresses this certainly in the context of folks who are under suspension or revocation orders by the FAA. But does this have any impact upon A&Ps, for example, who under some circumstances are permitted to taxi aircraft, but not necessarily fly them in the air? I think there may be even some categories of folks, maybe even in 121, Part 121 operations, who have taxi privileges for maintenance, but not the authority to go fly a 737. Can you help me with that, Representative?
Yeah, sure. So on page 2, line 22 and 23, last word did on line 22 and 23, we strike the language that talks about holding it, does not hold a valid pilot's license issued by FAA, and insert there prohibited from operating an aircraft, because an A&P mechanic may not be required to hold a pilot's license, but would be authorized to operate an aircraft for purposes of moving it from one hangar to another, or to fuel it, or any number of things. And yes, that goes to 737s. I mean, if they're checked out for ground travel and the airline wants to let them drive them around, they'll let them drive them around. So this hopefully cleared that up.
Yeah. The amendment being in front of us now and me having my glasses on my forehead, I see that you've done your usual good work. Thank you very much.
Any further discussion on the amendment? Seeing none, Representative Jennings, you may close.
I move the amendment.
Heard the motion, all in favor say aye. Aye. All opposed say no. Any further amendments? Okay, we are on the bill as amended. Is there a motion?
Move to pass it off favorably, Mr. Chairman, as amended.
We have a motion by Samsel, a second by Jennings. Any discussion? Seeing none, Representative Samsel, you can close.
Can you give me just 1 second to do something really quick?
I don't close.
We're all looking at our phones to see who Natalie's about to reach out to. Oh, okay, timeout. We're going to stand at ease for just a second.
I was just going to say, since we're on an aircraft bill, that Representative Samsel might be aware of the fact he has what we call an open mic.
I what?
Never mind, your microphone was on. It happens to airplane pilots regularly, sometimes with embarrassing consequences.
Well, I could share with the committee some of the things that I heard last night while reffing a rivalry between Representative Thompson's team and one from my own district, and that may get us all in trouble.
Okay, while we're waiting on Representative Ralph to review some language, just again, so I don't have to wrap up when we're done, I encourage you all to please read House Bill 2416 tonight. That's the one we got briefed on yesterday that we're going to have a hearing on tomorrow. I want you all to be as familiar with it as you can. I would also encourage you to begin reading Senate Bill 273, because at some point in time, I'm guessing that's the Senate bill on KEMA. I assume at some point in time we'll be discussing that either here or conferencing or something. So we need to, as a committee, be aware of it.
Can you say those again, please, Mr. Chairman?
Oh my gosh, 2416 is the House bill, the KEMA House bill that we had earlier. Senate Bill 273 is the Senate KEMA bill. Get to know them.
Thank you.
Okay, so that amendment that got distributed that was not Representative Jennings earlier, pull that one back up. And we're going to have Jason explain it if Jason's ready for that.
Yes,
I'm sorry, it's Representative Ralph's amendment.
Mr.
Go ahead.
Chair, I have an amendment, and I would ask for Jason to explain that, please. Very thoroughly, Jason, please.
Thank you, Mr. Chairman, and thank you, Jason Thompson with the Revisor's Office, and I apologize for all the confusion. I staff the Senate, so as you can imagine, I'm a little busy right now. The amendment prepared for Representative Ralph is due to some oversight on behalf of myself and the committee, Judicial Council Committee. When we amended these aircraft statutes to reflect all the testing and other things from 8-1001, we copied over a lot of the language, but we didn't copy all of it. And we also didn't catch that there were a couple of references to 8-1001 that might also need a reference to the comparable version under the aircraft statute. I think Natalie's going to share her screen in a second. Okay, she's working on that, so I apologize. We're coordinating that. And when you all have that, I know most of you have it in front of you, but now web access too. So here on page 1, we're adding several statutes to the title. If you go down to page 6, we're adding provisions to section 2, subsection P. These are provisions from 8-1023 and 8-1024 regarding testing that I basically lifted out of those statutes and placed here to be consistent with how we test under the vehicle statutes and the aircraft statutes. They concern medical care or treatment and costs and liability for those conducting the tests. But again, lifted from 8-1023 and 8-1024 to be consistent. The change then on page 7 is where we would put all of the new statutes that we would be pulling in and amend the repealer accordingly. And then those new statutes begin on attachment A, right below there. So Natalie could scroll down a couple pages. Perfect. The next one. So here on KSA 22-3437, that's it'll be section 5. You'll see it right there in the first paragraph, subsection A1. There's a reference to KSA 8-1001. We add a reference to section 2. So the testing and examination under 8-1001 and under section 2 are comparable and would be treated the same for breath test operators. That's what this one does. Then if I scroll down to the couple pages, section 6 is 60-427. This is the Civil Code physician-patient privilege statute. And if you keep going to page 5 of the attachment, you'll see there's a reference to 8-1001 about blood drawn at the request of a law enforcement officer. There's no privilege for that. So there would be likewise no privilege for blood drawn under section 2, the aircraft provision. So Natalie, if you could scroll down to page 5 of the attachment. Perfect, right there. So you'll see that in subsection E of 60-427, just lining it up with 8-1001 again. Okay, and then on page 6 of the attachment, we amend KSA 65-1,107. This is where the Secretary of Health and Environment has their rules and regs regarding the preliminary screening devices. And then on page 7 of the attachment, you'll see where we had 8-1001 reference for preliminary screening device. We also referenced section 3, where the preliminary screening device is for aircraft DUI. And then the final one on the same page, KSA 75-712H, this is where the director of the KBI has rules and regs for preliminary screening devices for oral fluid testing. That's referenced in section 3 of our bill, and this would reference section 3 just like it references 8-1001. So again, back to what I said at the beginning, all of this lines it up with 8-1001 so that they would be treated the same. Hopefully that helps.
Questions for Jason, Representative Carmichael?
Yes, Mr. Chairman. In view of a prior amendment that I made regarding rules and regulations and dates for their implementation, I think that all of the rules and regulations which have been referenced here in the attachment are already pursuant to existing regulatory authority. And I think I'm fair in saying that there, in fact, are rules and regs already in place. Do you know, Mr. Thompson, if that is generally correct?
Thank you, Mr. Chairman. Jason Thompson again. Yes, I believe that is correct. I believe these have all been promulgated and currently exist.
That's consistent with my understanding and satisfies my concern. Thank you, Mr. Chairman.
Okay, so we have a motion by Representative Ralph. Is there a second? Representative Jennings. We'll spread it around just a little. Any discussion? Not seeing any. Representative Ralph?
Thank you, Mr. Chair. And I just might say Jason's been doing yeoman work as well with the volume of information coming out of there. So no apologies necessary, Jason. I closed.
You've heard the motion. All in favor say aye. All opposed say no. Motion carries. Okay, Natalie and or Jason, help me with this because we actually had a motion to pass the bill out favorably and a second. So do I need to do away with that or?
Mr. Chairman, I think if it is fine with the maker of the motion and the second, they could renew that, or you could get a new
Okay.
motion, whichever.
So
you prefer.
let's see if renewing that works. So the motion was made by Representative Samsel and seconded by Representative Jennings. Are you both okay with that?
Yes, sir. Move to
Okay.
pass out as amended,
Thank you. Any discussion? Representative Samsel, you may close again.
I close again.
You've heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Affirmative votes, Owens, Hoheisel, Heiberger, Carmichael, O'Habasam. That's it, everybody. Thank you very much. We'll see you tomorrow. Have a good evening.